they're gonna read them anyway. All right, so Mr. Gates, all right, this is in the matter of the people of the state of Michigan versus Cody Wayne Gage. How do you pronounce your last name for me?
Gage, just like how you said
Gage? Okay, thank you. File number 23-21257FH. So, Mr. Gage, we are here today on a request and warrant for probation violation, which alleges that you allegedly committed the following non-technical probation violation, and that contrary to condition number 1 on your order of probation dated April 7 of 2023, you were arrested on or about April 12 of 2024 and charged with assault with intent to commit great bodily harm less than murder, child abuse 3rd degree, and child abuse 3rd degree in the presence of another child. Are these charges here in Lenawee?
that's correct.
Okay, here in Lenawee County. So Mr. Gage, and they're currently pending, is that right, Mr. Gage?
Yes.
Okay, and who is your attorney on that new file?
Not sure yet, working on it. I just got
Did you
arraigned
get
today.
arraigned already? Did you get arraigned?
Today.
Okay, today. And did you ask for court appointed?
Yes.
Okay, so they haven't appointed anybody yet. And when's your next court date?
I think, to be honest, ma'am, I'm not sure. I was hoping to get a piece of paper.
All right, so Mr. Gates, you also have a right to have an attorney represent you on this violation of probation, which I would highly recommend because anything you say here could be used against you in that new case downstairs. Do you understand that?
Yes.
If you can't afford to hire one, we will appoint you on a public expense. Would you like an attorney appointed to represent you?
Yes.
Okay, so here's what I'm going to do. I'm going to enter a plea of not guilty. We're going to put in a request for court-appointed attorney, and Miss Underwood is here this morning, or I mean this afternoon, still from this morning because we haven't finished our morning docket yet. So she will be back in just a second. She's speaking with someone right now, and then when she is done with her other case and another case, she will speak with you. Okay.
Okay.
All right, so I'm going to change your screen name. And it'll just be a moment. All right, I'll be right back. Don't move, just. Okay.
Okay.
All right, Miss Underwood, let me bring, oh, you got her back. All right, so Miss Underwood, how do you wish to proceed on behalf of Miss Heatherly?
I believe Ms. Heatherly wishes to enter a plea in this matter, Your Honor.
All right, so Miss Heatherly, I'm gonna need you to start the video for me if you could, please. Thank you. So Miss Heatherly, you wanna raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, yes.
All right, so Miss Heatherly, okay, so there's nothing about pending charges. Okay. So Miss Heatherly, do you understand you're currently on probation for uttering and publishing, and there's a 1-year misdemeanor, and then that's the ag assault, and let's see, what was the other one? Home invasion, third, which if I remember correctly, yep, is a 5-year felony. So do you understand if you plead guilty or found guilty, you could be facing up to 14 years in prison as well as 1 year in jail?
Yes, ma'am.
All right, now you would ask for court appointed counsel. I appointed Miss Underwood to represent you. Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
I am.
All right, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes, ma'am.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
I do, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, I do.
All right. So, Ms. Heatherly, how do you plead to the charge that you violated the terms of probation on each of these files by leaving Dawn Farms without successfully completing probation and failing to report on that date or any date thereafter to your probation officer? Guilty or not guilty?
Our breakout session ended abruptly. We didn't really finish discussing it. So I don't really know how to plead yet.
Okay, so you have a couple
Sorry.
options. You can plead guilty to failing to report to probation, or you can plead not guilty, or I can put you in a breakout room again with Miss Underwood.
Could I have another breakout room, please?
Sure.
Thank you.
There you go. Go ahead and join the breakout room.
It went away.
Yes. You know, I've been having a hell of a week, guys. I just called Gilbert Betsy. I saw Betsy right there. Is that it? That's a quote? Oh. All right, Ms. Underwood, I'm gonna close that breakout room. All right, so Ms. Underwood, how does your client wish to proceed?
We wish to schedule this for a hearing, Your Honor.
Okay. Probably need about, we got a subpoena, Christine Lindsay. Do you have any objection to Miss Lindsay appearing via Zoom? Miss Underwood?
No.
No.
Okay, so, Mr. Adams, I'm looking for about 45 minutes.
We could do. Looks like we could do September 5th at 10.
Miss Underwood, September 5 at 10 a.m.
That's fine, Your Honor.
Okay, and Miss Teskey will make sure the probation officer from the other county is available. And I would like that in person. So Miss Heatherly, you'll have to come in person, okay?
Okay.
And then Miss Heatherly, I need you to start reporting to your probation officer.
Okay, they're still in Monroe County, correct? Or is it to Saratoga now?
Well, because she's didn't report after treatment, she's come here.
It's our case, correct? So
Yeah, you're gonna have to come here Tuesday morning and report
Okay.
to, it's Miss Teskey, not you, right, Miss Walsh?
Yes.
So have her report Tuesday morning between 8 and 10. Yeah,
Yes.
Miss
okay,
Teskey.
because you absconded, you gotta report here. So Tuesday
Okay.
morning between 8 and 10, third floor of the courthouse to see Miss Teskey, all right?
Okay, thank you.
All right, thank you, your bonds continue.
Right, thank
You're
you.
awesome. All right, Mr. Getch, all right, so Miss Underwood, Miss Adams, did we send Miss Underwood the paperwork on Mr. Getch?
Yes, Judge.
Gage, I mean, all right, Miss Underwood, in the matter of the people of the state of Michigan versus Cody Gage, he requested court-appointed counsel, so I'm going to open up a breakout room for you and him, all right, Miss Underwood?
Yes, Your Honor.
All right. So there you go. Click on join that breakout room. Are you here on Pedro? Miss Walsh, are you here on Pedro Hernandez?
Yes, ma'am.
Okay, is he on your caseload?
No, it's Mr. Stevenson's.
Sunderwood, I'll close the breakout room. All right, Miss Underwood, have you had a chance to speak with your new client?
Yes, I have, Your Honor.
And how would you like to proceed?
Your Honor, we would ask the court to enter a not guilty plea on Mr. Gage's behalf. Mr. Gage has been, I believe, arraigned on new charges in district court, which encompass this violation, Your Honor. So we would ask that this matter be adjourned for 2 weeks to see what is happening with that case.
September 18th at 8:30?
Thank you, Your Honor.
Well, let's do September 18th at 8 a.m. All right, 9/18 at 8 a.m. So Mr. Gage, we'll see you back at that time, okay? And I'll enter a plea of not guilty on your behalf.
Thank you.
Thank you. All right, Ms. Underwood, did you receive the paperwork on Mr. Hernandez?
I did, Your Honor.
All right. All right, Mr. Oh, there we go. Good, good. All right, in the matter of the people of the state of Michigan versus, where are you at? Pedro Hernandez, file number 23-21526FH. Mr. Hernandez, we were here previously on an alleged violation of probation. You would ask for court-appointed counsel. Ms. Underwood was appointed to represent you. Mr. Hernandez, you are here on a violation of probation, which alleges that you consumed alcohol and committed the act of an OWI third and leaving the scene of an accident or any other crime back on August 4 of 2024. Mr. Hernandez is currently on probation for an OWI third offense, where the initial plea bargain was there would be no prison term. He is now facing a prison term. So, Ms. Underwood, have you had a chance to speak with Mr. Hernandez?
No.
I have not spoken with
All right,
Mr. Hernandez yet.
Okay, so I'm going to open up a breakout room and I'm going to assign Mr. Hernandez and Ms. Underwood to that breakout room. All right, there you go. All right, Ms. Underwood, I will close that breakout room. That didn't take long. All right, so Ms. Underwood, have you had an opportunity to speak with Mr. Hernandez?
Uh, Your Honor, Mr. Hernandez is currently facing an OWI third that is still in district court represented by Mr. Murphy. Obviously, Mr. Hernandez cannot make a plea on this, Your Honor. I would ask, Your Honor, the court to enter a not guilty plea, but I would ask the court to consider the following. Mr. Hernandez represents to me that he has a PR bond downstairs. I would assume that is with conditions. Being it's going to take some time to resolve his case downstairs, I would ask that Mr. Hernandez be given a PR bond with an alcohol tether, Your Honor, or testing such as the court would allow, along with daily reporting to Mr. Coast. Mr. Hernandez stands to lose everything if he can't get out of jail and work and.
Well, Mr. Hernandez works for his family, so I don't think he's gonna lose his job, but Mr. Hernandez is looking at a prison term. Mr. Stevenson, would you like to weigh in?
May I speak?
No, not yet, Mr. Hernandez, you can't speak. I asked Mr. Stevenson a question. Mr. Stevenson?
As we're aware, he's on probation for OUIL third. He's not permitted to use alcohol, not permitted to drive. He did
I was
both.
never driving.
Mr. Hernandez, be quiet. Mr. Stevenson, proceed.
He did both. He doesn't have a valid driver's license. I believe he needs to stay in jail and face these OUIL third charges again.
All right. So in this case, originally, we suspended his initial jail term. He got a really good plea offer from the prosecution, 30 days jail, suspended, 48 hours to be served immediate, and no Michigan Department of Corrections up front. The allegations are, again, that he committed an OWI third and left the scene of an accident. I, at this time, do not believe he's at risk of losing his job since he works for family.
My home. My kids have been staying with my
That's
parents.
why you don't drink and drive, Mr. Hernandez. So no, you are a danger to yourself. You are a danger to others. You are a danger to our children driving on the street. So no, you obviously have not been able to comply with your bond conditions previously, as well as this. So no, your bond will be set. I set your bond at, let me see. No bond, so I will change your bond to 25,000 cash. So,
it was that
is all. Thank you, Mr. Hernandez. You have a good day.
Thank you.
Thank you. And we'll see you back. I'll set him for the same day I sent the other, September 18th at 8 a.m.
Thank you, Your Honor.
Thank you.
Is that everything?
God, I hope so. That was quite a morning. So thank you, Miss Underwood. I appreciate you. Bye.
Just me, okay. Magical doors, you know which door we're gonna come in, right?
I'm gonna drop down from the ceiling like Tom Cruise. So we should-
Yeah. It'll come up, so, yeah. Put something on the record?
Yeah.
Okay. Awesome. All rise.
Yes.
All right, this is in the matter of Mary Olivia Wesselek versus Christopher Ray Hangman, file number 23-50237 DM. I have Lowry Rains appearing on behalf of the plaintiff and Adrian Iddings appearing on behalf of the defendant. This is a date and time set for several motions, but it's my understanding the parties have worked out an agreement of a temporary or interim or.
Yes, Your Honor, that is correct. And if I can, I'll place this on the record and then we, in case obviously, Mr. Rains, if there's something I forget, he can follow up. Yes, Your Honor, there were several things that were going on today. And after Mr. Rains and I speaking to the court and both of us speaking with our clients and counseling and trying to get this case back on track and get these people moving forward, they both agreed to an interim order. And we are going to, Mr. Rains and I will have our staff send a email chain so that we can get a review date from Ms. Adams in January. So we've both agreed to that, but this order is going to take effect immediately. So this is what the parties have agreed for an interim order. We are going to allow the children for the 24-25 school year. They're going to be enrolled in Utica schools. My client needs to produce proof that the kids can be enrolled in Utica schools, which would, he's already researched that. It's either a lease, which he has, or utility bills or something of that nature, but he will provide that to me and I will give that to Mr. Rains. If for some reason the children could not be enrolled in Utica schools, the school district between the parties is Clawson, and the children would go there, but my client has already checked that and will provide proof to me so they can be involved, they can be enrolled in Utica schools, and that would be all 4 children. The parties have also agreed that the request that was in the order that was entered from, I believe, July 15th, is that right? July 15th?
I believe it was entered on the 16th.
Entered on the 16th. Can I see it here? The order on July 15th, what the court had signed was that plaintiff mother could obtain a policy of health insurance for the minor children, and she's done that, and that will continue. That she will enroll the minor children in Oakland. Psychological services and counseling sessions will be scheduled by her during her parenting time. She has begun that. I believe they have their 3rd session with mom tomorrow, I believe. My client was under the understanding that he also had to start to enroll the kids in counseling. He understands that he does not need to do that. So he will, instead of trying to do separate counseling, which the kids don't need, they need one counselor, he will contact Oakland Psychological Services to give his information if Ms. Wesselek has not done that already, so that he can participate based on the counselor wanting his participation. And we've also agreed that the minor children, the parties' minor children, can have contact with Ms. Wesselek's now husband, Miles Aston, during her parenting time, but she will supervise that parenting time. So she will make sure that obviously that she is there at all times when she has her parenting time and her husband is present. And then, as I already said, Your Honor, we will contact Ms. Adams and do a review hearing in January, and hopefully things are going well both in school and with the counseling with Ms. Wesselak, and this order will take effect immediately.
Any additions or corrections, Mr. Rain?
I think that is all accurate. The Sittings has accurately set forth the terms of the agreement. I just wanted to say for purposes of expediency, I believe that Ms. Sittings and I are in agreement with that order following hearing on July 15, 2024 being essentially reinstated. So it would be the intention to pull forward into this upcoming order these same provisions that were in that order that Your Honor had signed of that was filed with the court on July 16, 2024. I mentioned that only because that order has been set aside, but that would be essentially reinstated. I do believe that that's accurate, Your Honor. Ms. Sittings, we trust, will provide with that proof of residency that would enable the children to attend Utica schools. I just would add that if that cannot be produced, we would expect then the cooperation of Mr. Heyman with the enrollment of the children in the Clawson schools very expeditiously, because the enrollment deadline is August 23, which is, I think, some 9 days from now. But we trust that his representations that he'll be able to satisfy the residency requirement. So yeah, and that's correct, Your Honor. All of the other matters that were scheduled for today, the defendant's motion for change of custody, our objection to the ex parte order setting aside our order 715, the motion for change of school district, as well as our or the plaintiff's verified motion for entry of an ex parte order to show cause for contempt. Those would all be scheduled for hearing at a review hearing, I believe. So we're only going to need approximately half an hour of the judges of Your Honor's time.
How far out do you want that? 30 minutes?
In January.
Of 25, Your Honor.
Ms. Adams, could I get a January of 25 review hearing date for 30 minutes?
Okay, do you want that not on a Monday then, or?
Say it again?
Do you want that not on a Monday then?
Not on a Monday.
Okay.
Maybe like 1:30 on a Tuesday, Wednesday, or Thursday.
Your Honor, we would be just briefly, we would be vacating that hearing date that you had previously said of September 20th.
Yes.
All right, so the September 20 date is vacated.
Yes.
Judge, we could do 1:30 on Thursday, January 2nd, or Friday, January 3rd.
January 2nd on a Thursday at 1:30 p.m. And that can be via Zoom if you want.
The second or third, either one is fine.
Either
for us.
day.
Right.
Yeah.
We'll do January 2nd at 1:30 p.m. and you can do that via Zoom or,
Yeah, via Zoom would be fine.
okay, that'll be Zoom. All right. Anything else we need to place on the record?
Not at this time. So the only thing I wanted to make sure, Mr. Rain, so we're reinstating, like we talked about, that prior order that was set aside, and then I'll have to do a separate order for the school district and those provisions. I can do that. Just to follow up, because we did, whether we call it an interim order or not, I need to do something for the school as well.
That's fine. I would suggest that council, maybe just the one order references that the July 15 order is reinstated.
I can do it that way.
Yeah,
That's
maybe
fine.
just a single order.
Yep, I can do it that way. I'll just incorporate that and refer to that July 16th order, and then add the school district language that we just talked about.
All right. Okay. All right. Well, thank you all. And I wish you the best of luck with school this fall. Mindy, thank you.
Thank you, Judge.